I don't have anything to say about Medicare or Social Security, but some people did. From this book, Louis D. Brandeis, Felix Frankfurter, and the New Deal. I've read this before. You see, at the time when I read it, it had one context. But, page 112. When Congress finally passed the Social Security Act in August 1935, neither man made any comment in their correspondence. Frankfurter did not write his usual congratulatory letter to the president. Unfortunately, neither Frankfurter nor Brandeis rendered a written critique of the act, so it is difficult to know exactly how they felt about it. The act did have the tax offset feature as well as merit rating, which strengthened its decentralist character. In fact, it was in some ways even weaker from a nationalist perspective than the earlier Wagner-Lewis bill. This was not entirely due to Brandeisian scruples, but to congressional conservatism, which gave the states power out of a suspicion of federal power. Congress also deleted the original requirement that the states select personnel on merit. Still, the silence of Brandeis and Frankfurter probably did not indicate total disapproval. The act was not as good as the earlier Wagner-Lewis bill, but at least it followed the Wisconsin plan in broad outline. Brandeis continued to believe in the efficacy of that plan, citing evidence to Frankfurter 2 years later of the fine record compiled by the Wisconsin program in helping to achieve regularity of employment. By 1939, however, the administration of the national plan had disillusioned him, and he was informing his visitors of the heresy of the prevailing unemployment compensation system. The passage of the Social Security Act was at best only a partial victory. Now, there's another part in here. You may not get what you're looking for. Doesn't seem like that's what you're getting for right now, right? There we go. Quite apart from the revenue generated, Brandeis's tax program was a reform measure designed to combat the curse of bigness. But this program was also essential in Brandeis's recovery strategy, for it alone could produce the money necessary to end the Depression. Economic recovery, Brandeis observed, required a comprehensive program of great magnitude in which a massive governmental venture into public works was essential. But he was not content simply to urge great expenditure because the nature of the projects was of great importance. He advocated permanent investments for projects of lasting social value. Although he did not describe the projects in detail, he mentioned such things as afforestation, flood control, soil erosion control, irrigation efforts, navigation improvements, and the creation of lakes and ponds. He also showed interest in slum clearance, adult education, and a variety of other social programs. Brandeis advocated quick action to put 2 million men to work within 6 months, along with another million or two indirectly. This massive commitment would turn many a wheel now inert. Such an effort would help other New Deal programs because it will so hearten folks everywhere, and particularly on the Hill, that it will make it possible for Roosevelt to put through his other measures. Most of the projects would not arouse hostility because business and property values would not be threatened. Strong opposition would come only from the super rich. Although he did not spell it out in detail, Brandeis seems to have envisioned a kind of revenue sharing. He wrote Frankfurter that the program could be financed by loans initially and then by high estate and income taxes with share to the states. Now, I think you've got a time limit or a time frame here that you're looking for, right? There's a time indicator that needs to be met, and there are specific parameters regarding a particular concept of what would be acceptable to meet what you need. You need Medicare, and you need something saying that they're thankful. Right? Am I correct? I heard you. I just don't genuinely, honestly have anything to offer in that regard. So I would have to borrow from the public trust. Right? Well, the bearing is all off. Who or whatever is in need of this is not attenuated to what would be something I would actually provide you with of my own volition. It's all off. Now, is that to your liking? Is that something that makes you feel like you've succeeded? The gold cases challenged the right of Congress to nullify the gold clause in private and public contracts. Hughes again wrote the majority decision upholding the government by a vote of 5-4. The four horsemen dissented. Hughes argued that there is nothing in the Constitution which prevents Congress from invalidating contracts in the pursuit of government policy. Brandeis concurred in a decision clearly based on economic expediency. Quote, "It is a relief to have the gold clause case out of the way, but I feel little satisfaction with the administration's performance. McReynolds' talk was very different from his opinion. It was really impressive, better than anything I have ever heard from him." End quote. So, that's important. Why? Because we just had a discussion of the gold cases, didn't we? What was the discussion of the gold cases? Well, that was another book. It's in here. The whole point of the gold cases had to do with retroactive laws, if I'm correct, right? What it means for Congress to pass laws that are actually unconstitutional and to basically get away with it for a long time. And then at some point to have to address what it means to have engaged in unconstitutional action unchecked by the judiciary for a substantial period of time, and then have to revise it. What is a constitutional issue? No state shall pass any law impairing the obligation of contracts. U.S. Constitution, Article 1, Section 10, from The Dirty Dozen by Robert A. Levy and William Miller. Page 50. It must have been nice to own a 143,000 square foot office building on a prime downtown corner in a major U.S. city, fully leased long term to a large insurance company. There was only one hitch. By law, no rent increases were allowed for 6 decades. From 1933, shortly after the building was erected, until 1993, when the owner was finally able to obtain legislative relief. During that 60-year period, the lessee paid a mere $23,000 in annual rent, about 20 cents per rentable square foot, compared to 1993 market rates of roughly $14 per square foot. Here's how it happened. Property owner John Trostel constructed a 14-story building in Des Moines, Iowa in 1931, and then leased it out for $23,000 annually, plus the usual leasehold expenses. Instead of a cost of living escalator, Trostel protected himself against inflation with a gold clause, a common provision at the time. They gave the lessor an option to demand payment in gold rather than dollars. Big mistake. Trostel never figured that 2 years later, in 1933, President Franklin D. Roosevelt and the New Deal Congress would abrogate all gold clauses, ostensibly to maintain government reserves of the metal during the economic emergency of the Great Depression. The government might have provided that assets other than gold could be substituted as a medium of payment. Instead, the president and his fellow New Dealers wiped out existing lease provisions and gutted the rights of property owners as if they never existed. Lessors such as Trostel were not permitted to replace their gold clauses with different escalators. They were not allowed to renegotiate their leases. They received no compensation for the diminished value of their property. Incredible? Perhaps so. But in 1935, a bitterly divided Supreme Court upheld Congress's 1933 resolution in 3 companion cases that became known as the Gold Clause cases. Chief Justice Charles Evans Hughes wrote the majority opinion in each case over dissents by the so-called Four Horsemen, Justices George Sutherland, James Clark McReynolds, Willis Van Deventer, and Pierce Butler. The lead case was Norman versus Baltimore and Ohio Railroad Company, in which the Chief Justice applied his expansive vision of judicial supremacy. We are under a constitution, but the constitution is what the judges say it is. Hughes concluded that Congress could override private contracts to the extent necessary to regulate the value of money, a federal power expressly enumerated in the Constitution. The rationale assumes, incorrectly, that Congress's only constraint is to act within its enumerated powers. More precisely, the federal government, even when performing one of its enumerated functions, may not do so in a manner that violates rights, enumerated and unenumerated alike, secured by the Bill of Rights and other constitutional provisions. When Congress abrogates contracts and confiscates property, even if purportedly executing an enumerated power, this is Nero at his worst. The Constitution is gone. Those were the trenchant words spoken extemporaneously when Justice McReynolds read his dissent in the Gold Clause cases from the bench. Furthermore, he wrote, "The Gold Clause is in no substantial way interfered with the power of coining money or regulating its value or providing an uniform currency. Their existence, as with many other circumstances, might have circumscribed the effects of the intended depreciation and disclosed the unwisdom of it, but they did not prevent the exercise of any granted power." That dissenting perspective provided little solace to John Trostel, 1935, or to his granddaughter, Anne Trostel Galbraith, who controlled the property in 1993. For 6 decades, she and her family had leased a 14-floor building, receiving no more than $23,000 in rent each year. Even if the family had attempted to unload the building, prospective buyers, knowing that the rent was frozen at Depression-era levels, would never have paid what the property was worth. Finally, in 1993, Miss Galbraith was able to take advantage of legislation that revived gold clauses, passed by an insightful Congress, shrewdly aware that the Great Depression had ended decades earlier. Meanwhile, the price of gold had multiplied nearly 20 times, so that the lessee, an affiliate of insurance giant Conseco Inc., owed not $23,000 annually, but roughly $460,000. Not to worry, in the interim, the insurance company had sublet a large part of the space. At market rates, about $12 to $16 per square foot, the building was capable of generating $1.4 to $1.8 million in annual lease fees, even after subtracting its expenses and the $460,000 owed to Mrs. Galbraith. Conseco made a sizable profit on the deal. Of course, there's a broader question here that transcends the financial losses of the Trostel family and the windfall to Conseco. How could Congress, without violating the Constitution, have retroactively changed the law in effect when the original building lease was negotiated? According to the Contracts Clause in Article 1, Section 10 of the Constitution, state legislatures are not allowed to pass any law impairing the obligation of contracts. The federal government is similarly constrained by other constitutional provisions. Yet the New Deal Congress paid no attention to that constraint when it rescinded all gold clauses. In the process, Congress flouted 3 of the central premises underlying the ban on impairment of contracts. First, the principle of private autonomy. Respect for the rights of each individual means that all persons must be at liberty to dispose of their property and their labor as they wish. By allowing people to order their affairs through contract without government intervention, the Constitution fosters individual self-determination. When government abrogates private contracts, it intrudes upon personal liberty. That is why the framers crafted the Contracts Clause, to promote personal liberty by grounding economic transactions on the right of free exchange, insulated from legislative pressures and the impulses of temporal majorities. Second, the rule of law ideal. Government must announce its rules in advance, avoid applying the rules retroactively, and ensure equal treatment under the law. As a result, individuals will be able to predict with fair certainty how each rule will be implemented and plan their affairs accordingly. If existing contracts are altered by government edict, planning by private actors will be undermined. If rules are applied selectively or discriminatorily, the potential for abuse is obvious. Legislators will be tempted to use the coercive power of government to advance the interests of those with political muscle or exact retribution against unpopular groups. Third, the separation of powers principle. The Contracts Clause was designed in part as a check against concentrated government power. Under our system of government, the legislator's task is to address broad political issues prospectively, not to examine in specific cases whether the laws have been properly applied and obeyed. The judiciary's function is to review individual cases after the fact, but not to design prospective rules that address questions of policy. In that sense, the Contracts Clause prevents the legislature from assuming the institutional role of the courts, reserving to the judiciary the job of resolving individual contractual disputes.